So, hi everybody. It's Linda Gould from Democrats Abroad Japan, and I'm here today with David Litt. That's one of the things that has disturbed, I think, a lot of Democrats and liberals for a long, long time is this idea that corporations are people and that money equals free speech and that corporations have the same rights as individuals, but they don't have the same like prosecution or the same, I'm not sure of the proper word, but I wonder if you could talk about that a little bit since you brought it up in this case. Like, I think that's something that a lot of Democrats would be really interested in hearing your views on how we got to this point, and how is there any way out of it.
I think there are a couple things going on. I think the First Amendment rights of corporations in Citizens United, that's a very difficult thing to solve. Either you need to change the membership of the court and have them overturn their own decision, um, or you'll need a constitutional amendment. I think because it's an interpretation of the Constitution, it's very hard to come up with legislation that would solve that problem. And that case and this, I think it's Buckley v. Vallejo, much older case involving federal election regulation of speech. Both are constitutional cases and limit the ability of Congress or the Federal Election Commission to do anything about it. So either the court will need to change its mind, which will most likely only happen with a change in membership and a willingness to overturn precedent, neither of which are likely to happen quickly.
No.
Or you'll need a constitutional amendment to deal with it.
But how did we get to the point where we're in a situation like the one that you gave, where we have a company that can use individuals' first rights against them to prevent regulations that would help the individuals?
I think system where the Constitution was set up in looking at government as a source of tyranny and government as something that we need to be protected against. And if you look at the history of totalitarianism in the 20th century, that's also not unreasonable to say that the purpose of these constitutional protections is to protect us from government. And that they're not really, and that if they're not made available in some way to corporations to some degree, then they won't serve their purpose. Because if wealth is in corporate form and the government can just expropriate the wealth from the companies, then the fact that we individuals have protections isn't really going to do us much good. So I think but we have to recognize that corporations are inventions of the legal system, and that we can't restrict our flexibility to say, well, we're going to give the corporation some benefits. Unlimited life, limited liability, all sorts of different benefits in terms of taxes and investments and things. And we ought to be able to not give it all of the rights that we give to individuals. And particularly when it comes down to money and speech, and equating the two, and then giving that right to corporations. I don't think that's something that the court needed to do. I mean, there is a whole jurisprudence around commercial speech saying that commercial speech is entitled to some protection as well, but it's not entitled to as much protection as, say, core political speech. And so I think the court could have gone the other way.
Do you know when there were decisions made on the issues that we're talking about? Like, is this something that's happened in the 80s and the 90s?
I think some of the issues about giving corporations, constitutional rights to due process, things like that go way, way back. The era of the famous case is Lockner. Is called, when you say the court is engaged in Lockner type activities. This was during the 1920s and in the early years of the New Deal, when everything that the Roosevelt administration came up with was struck down by the Supreme Court on very expansive constitutional interpretations that limited the ability of the federal government to regulate what corporations were doing. And that was done based on this economic due process idea that the court changed its membership. There was actually a plan to pack the court. Roosevelt wanted to expand the size of the court so that new justices and the more friendly existing justices could outvote the old guard. What happened instead, that was a very, very controversial thing for obvious reasons. In fact, some of the old guard retired or died, and there was a change in the membership of the court, and so the court packing plan didn't go forward. And the court learned the lesson and was much more hesitant to limit economic regulation. Said, well, the power of the federal government to regulate interstate commerce clause is effectively unchecked, and there are not many things that the federal government can't do. Now, more recently, with the challenges to Obamacare and a few other challenges that predate that, you see that the court again is saying that there are limits to the Commerce Clause, and then you have application of the First Amendment and some other provisions where corporations are asserting constitutional defenses to regulation. I mean, at the end of the day, we would hope that if the court is representative, if the political system is working well, Congress is doing its job, then all of these things will get ironed out in the wash ultimately.
That's a lot of ifs.
If Kavanaugh is appointed, you will have at least several Bush appointees, and this would be the second Trump appointee, who are appointed by presidents who did not win a majority of the popular vote.